Talking about the legal framework of e-governance, there is one area of law that is very important to talk about and to stress, and this is data protection and the protection of privacy. It's not something that's related to just e-governance. It's not even related just to the e-world, to modern technologies, but there are definitely new issues that come forward when we talk about e-governance or e-transactions of any kind or any use of modern technologies. And we have to think about these issues if we do not want this very positive introduction of modern technologies to help us with governance, to help us with all sorts of things in our daily lives. We really have to think about not to make us as individuals less secure, not to actually violate our human rights by introducing these new technologies. So this is one of those issues that, as I've mentioned in another lecture, one has to think about from the beginning when introducing e-governance. One has to think about how to take into consideration data protection aspects. There are a number of different things that I want to outline about this very important right. First of all, maybe just briefly what it is. Data protection is a more modern term than the protection of privacy. And they are not the same thing, but they are linked. And that can be seen also in the legal handling of this, how we have in important human rights instruments, like for instance the European Convention of Human Rights or the Universal Declaration of Human Rights, we have the protection of privacy. And that has been used as a basis for cases also on data protection, because it's quite unusual and quite recent to have specific protection for data rather than just as an element of the protection of privacy. We do have that in the Charter of Fundamental Rights of the European Union, which entered into force in 2000, so a much more recent document, which actually mentions both privacy and data protection. But this link is important to understand what it all is about. The protection of privacy protects also things like letters, traditional letters, the protection of the home, that nobody can violate your home, or your right to decide about your private matters, your family life, etc. And one aspect of that is then the protection of data. And the more specific right then focuses on the data as such. It's a more concrete right related to the different informations, not linked to the form. And here I would say that one of the key issues to keep in mind, the key principles of the legal framework, is that it is the substance and not the form that is important. It doesn't matter if certain information is written on paper or if it is in electronic format. It's important, what is that information? How sensitive is it? Is it something that actually is known anyway? There used to be printed phone books, for instance, with people's names and addresses and phone numbers. It's nothing sensitive. Just because it's kept electronically doesn't make it more sensitive. But if it is a health record, for instance, it is very sensitive. And again, it's as sensitive if it's kept electronically as if it is on paper. So it's always the content, the substance, and not the form that's the key. But this said, there are then still new risks with electronic data, which is why the whole concept of data protection is something that has arisen more or less at the same time as electronic data handling. The first legislation on data protection was in the end of the 1970s in Germany, in one of the Länder in Germany, but the first nationwide law, which was in Sweden, was in the 1980s, and from about that time many countries in the world have adopted data protection legislation. And this is because when data becomes electronic, it's intangible. It's not so easy to see where it is, how it is kept. And when we talk now concretely of e-governance, this is very much the case that, as you will have seen, for instance, from this illustration of the Estonian X-Road, this interoperable databases system, you'll see that there are a number of different databases, not one huge one. That's very important. We don't want to have a single point of failure. There are separate databases with separate security systems, servers, etc. But there is a lot of data that's moving around that can be accessed from different places. It's more difficult to conjure up the image and to know where and what it is than if this was books that we had to transport in a traditional way. I think in only a few years from now that difference even in images of it will disappear when we get more and more used to it, but it's still so that there are traditions of how to protect data traditionally, which may not still be there when it comes to electronic data. So it has to be thought about that the technology is used positively, not allowing more dangers, but actually the other way around. For instance, one example from Estonia is that when data in a person's files is accessed by an authority, this leaves a footprint. It is seen that somebody has accessed my data in a way which is not if somebody just goes and reads it on paper. So we can actually use technology positively to make it more secure. But we must also remember here, we must remember people's perceptions. A lot of people are worried when it comes to electronic data. They think that this is insecure, and unfortunately very publicized recent scandals of all sorts of snooping, government surveillance, or of private companies, data leaks, etc., have not exactly helped to make people more secure. So there is a problem also with people's perception, and we mustn't forget that also for that reason it must be known, transparent, how is the data protected, how is it secured. And for this it's very important to have an implementation system. So data protection legislation should consist of measures that must be taken by anybody who handles data, but also by a system, an inspection, an inspectorate that monitors that these rules are actually properly followed. So data protection legislation is there to make sure that our private life, our private data is at least as secure in an electronic world as it is in the traditional world. And this is very important when it comes to governance, because here people often have to give the data. It's not like joining websites for entertainment or even buying things online, which is a choice. But for e-governance, if people are supposed to do their transactions electronically, they have to give certain information. They have to know that this is secure, that it is handled properly, that there won't be any risks with it. And this whole system must be very transparent. So I thank you for your attention.